One of the turning points in Watergate was Richard Nixon's attempt to defy the request for evidence by impeachment investigators and his ultimate failure at the Supreme Court. President Trump's also trying to defy lawful requests for information and congressional subpoenas for his staff to testify. And in some cases, witnesses are ducking Congress, teeing up potential court clashes like what Nixon saw.
4 witnesses failed to show up for depositions at the direction of the White House.
All of them have been subpoenaed.
A no-show on Capitol Hill.
Most of the witnesses scheduled to testify the rest of this week are not expected to appear.
We all remember those moments. We've asked viewers for questions about impeachment, and here's one that's come up a lot from many of you. Aren't there consequences for people defying these subpoenas? Well, let me get into it. There are 2 simple answers. First, Congress can play hardball. They can send the sergeant-at-arms to arrest people who don't show. Back in the day, this used to really happen. In 1927, the sergeant-at-arms actually arrested the brother of the attorney general. But Congress has not deployed this tactic in over 100 years. The other answer is how we usually see these play out, including in the Nixon cases. Congress asks the other branch of government, the courts, to enforce subpoenas. Now, Trump's Justice Department has taken some extreme positions here, arguing Congress shouldn't be able to enforce its subpoenas at all in court. That led to a judge recently asking DOJ lawyers, basically incredulously, are you actually arguing the House can never go to court? DOJ replying, correct. The Constitution does not allow this. Now, that is a far more extreme claim than other presidents. Bill Clinton did agree Congress could enforce its subpoenas, but he argued that private litigants shouldn't be able to sue the president for matters that occurred before he even came into office. And he lost that narrower claim in the Paula Jones civil suit. Nixon also agreed on cooperating with some investigations. He, too, made a narrower claim that his own presidential conversations should be secret under executive privilege. Again, narrower in its view of presidential power than what Trump's claiming now. And even that Nixon view, well, it was famously rejected by the Supreme Court unanimously.
President Nixon has not yet responded to the sledgehammer decision of the Supreme Court today, which ruled that he must immediately turn over tapes of 64 presidential conversations. The court rejected 8-0 Mr. Nixon's claim of absolute privilege on those tapes.
That was the turning point. Nixon was out of the White House 16 days later. His privilege claim was also weaker because he was facing a criminal probe, a special prosecutor, not the Congress. The Supreme Court could come down differently for demands from the Congress. We don't have much of a guide here because a case pitting executive privilege against Congress's demand for information has never reached the Supreme Court. A pretty astonishing legal fact noted by the New York Times' Emily Bazelon. Now, that's partly on purpose. The courts try to avoid resolving political battles between the other branches of government whenever they can. And also, the other cases that have come close to impeachment, as we've been reporting tonight, typically did involve prosecutors and not just a House committee battling the president. Unlike Nixon, President Trump has faltered, though, already in his stonewalling strategy, and that's before anything gets to the Supreme Court. His own hand-picked aides, like Gordon Sondland, testifying against him despite Trump's demands that everyone simply defy these congressional requests. And as we look towards next week, a lot of talk about whether John Bolton will also end up testifying. He says he's ready to if a court approves it. All of that is one reason why Chairman Schiff says the Democrats have most of the key evidence and they won't be drawn into a court battle that could last years.
We are not willing to allow the White House to engage us in a lengthy game of rope-a-dope in the courts, so we press forward.
Is that the right legal strategy? If the White House is hiding really crucial evidence, could Congress get a faster, targeted ruling from the courts? And should any of all this stonewalling be considered as an article of obstruction, an article of impeachment itself against President Trump? Hey, I'm Ari Melber from MSNBC. You can see more of our videos right here, or better yet, subscribe to our YouTube channel below. You could have been anywhere in the world, but you're here with us, and we appreciate that.